appeal in the matter of Quadra Commodities S.A and XL Insurance Company S.E and others.
Good morning, my lords.
We've got a rather odd situation. I seem to have a kind of loan, computer on loan for LiveNote. Neither of my colleagues was aware that LiveNote was being provided and hadn't brought in the computers. And when I looked at it this morning, it's only there for the purposes of a transcript.
Correct.
So I asked the question, do we really need to have it running during your submissions, Ms. McNaughton, because we can take a note?
I'm entirely neutral on the point. So it's for your benefit. If you like it, you can keep it. If you don't,
just slightly. No criticism of Opus 2, who do a splendid job and all the rest of it, but it sometimes is slightly sort of distracting when it's running. But I don't know what my colleague, whether anybody wants a computer.
I don't think it.
In which case I'll shut it.
Do that. If you ask me to remove it, I won't be able to help you, but I can make sure someone does.
Well, if we need to look at the transcript at some point, we can. Yeah, sorry, Mr.
If I could start with the usual introduction, my lord. I appear with Ms. Sandra Healy on behalf of the appellant, the insurers, and my learned friends, Mr. Jordak Kershid, KC, and Ms. Anna Gotts, appear on behalf of the respondent, Quadra. My lords, as you know, this is an appeal from a decision of Mr. Justice Butcher, who allowed Quadra's claim for an indemnity under a cargo insurance policy. Now, my lords, before I start, just a couple of matters of housekeeping to raise with you. One touches on transcribers. It is being transcribed as we speak. And of course, at least in the commercial court, it's not unusual. In fact, it's common to have a break halfway through the morning and the afternoon for the transcribers. I don't know if my lords wish to allow that to happen on this occasion or not.
The problem with it is that we say we have a 5-minute break and it becomes a 10-minute break.
Yes. I'm in your hands, my lords. If
I've had some experience of this because I always used to try and insist on not having a break. And I was told by Opus 2 that health and safety meant that one transcriber couldn't go through the whole session. And when I suggested that they might just like to swap transcribers seamlessly, I was told that they needed the time to log out and log in, and therefore it was necessary to have 5 minutes. So I did reluctantly agree to 5 minutes, but insist on it being 5 minutes.
Another possibility,
We'll agree to 5 minutes.
Well, I was going to make
it is 5 minutes.
I was going to make a suggestion, and I appreciate this suggestion may take 5 minutes, but I don't mean to. But the suggestion is, of course, these transcribers could just stop transcribing for 5 or 10 minutes as they wish, and pick it up again, and then they can fill in the blanks afterwards.
Well,
So
that doesn't work.
I don't think that works. Let's have we'll have a 5-minute break. Let's not waste more time on that.
Now,
Just whilst we're on that, because this afternoon we have the swearing in Mr. Justice Bright, which certainly I think two of us need to go to.
I think
we
more
need
from
to
the
rise about 4 o'clock.
Very good.
But we think we've got plenty of time for this case.
Yes, well, that was my second point of housekeeping. We understand we've got 2 days for this appeal.
Yes.
That's your understanding as well, I hope.
Yeah.
Good. Very good.
Yeah.
So as I say, my lords, this is an appeal from a decision of Mr. Justice Butcher. It's a case which concerns a warehouse fraud and the circumstances in which a claim can be made under a cargo, that is a property insurance policy, arising from such a fraud. Now, strange though it may seem, I'm not aware at least of any decision which touches on these sort of factual circumstances in relation to a marine insurance policy. Even though warehouse frauds have occupied the court's time in other contexts, I'm not aware of a case where it has touched the court's decision-making in relation to this particular context. Now, as far as the facts are concerned, there's evident from the party's skeleton, but it is probably worth looking at what Mr. Justice Butcher said in his judgment, and for that purpose I'd ask you to look at the core bundle.
Yeah.
Tab H, page 121. And at the bottom of the page, there's a heading, Nature of the Fraud. And it begins, the evidence of Mr. Scott included the following.
Mr. Scott was your client's loss adjuster.
Yes, he was investigator, I think. In essence, I understand from my investigations that the Agroinvest fraud was a scheme whereby Agroinvestgroup would obtain grain, corn and sunflower seed from local farmers, which were stored in a number of elevators that the group owned throughout the Odessa region of southern Ukraine. And the fraud was then perpetrated by the Agroinvestgroup, pledging and or selling the same parcels of agricultural commodity products to multiple traders via the issuance of fraudulent warehouse receipts. It is apparent from my inquiries with trade and industry sources in Ukraine and also from press articles that the same parcel of grain or seeds may have been pledged and or sold many times over to different traders. In paragraph 49, this is the judge speaking, it was in effect common ground between the parties at the trial that although the details were unknown, this was how the fraud had occurred. In simple terms, the elevators owned or operated by the Agroinvest Group issued multiple warehouse receipts in respect of the same goods to different buyers. Some reports suggest that up to 5 or 6 warehouse receipts may have been issued with respect to the same grain. When it came to the point of executing physical deliveries against those warehouse receipts, there was not enough grain to go around. In January 2020, the president of the UGA, that's the Ukrainian Grain Association, estimated the total losses at about $80 to $120 million. Now, the claim in this case relates to one parcel, which is in very approximate terms about $5 million, just under, I think. The elevators, which are referred to in Mr. Justice Butcher's description, are essentially facilities which are made up of a number of warehouses, and within the warehouses, a number of storage or cargo bins. And you can see that, my lords, from paragraph 47.1, which is the previous page of Mr. Justice Butcher's judgment. And this is having regard to the evidence of the Bastico inspectors, and we'll come back to their reports later, that each of the Zaplaski, Bilgorod, Ismail elevator sites, so they're the 3 relevant sites for these purposes, had comprised multiple individual warehouses. Commodities stored in those elevators are not usually segregated by the owner. The elevators stored different grains and different grades of particular grains, and the evidence indicated that these grains and grades may have been moved between silos. So,
Did the evidence disclose how many different elevators or sites were run by Agroinvest that were the subject of the fraud?
I'm speaking from memory, I think about 10 sites throughout Ukraine, but there were only 3 which concerned Quadra.
Thank you.
Or at least for the purpose of this claim. I think they may have had other material in other sites, but this is where the claim arose. Now,
Presumably they're called elevators because they've got those sort of moving belts which the grain is put on.
yeah, I mean, I would
to go into the silo.
That's my understanding. Although that betrays the fact that you're actually looking at one piece of machinery within the facility, and the facility is actually a large area of land made up of separate buildings, which include, and I think there may be elevators within that. So when I always thought of it as silos rather than elevators, but
Yes.
elevated refers to the entire complex or the facility rather than individual buildings within the facility. So.
Okay.
Now, just for my lord's benefit, there is a chronology which I'm not proposing to go to at tab 6 of the core bundle, but the relevant period is September 2018 to January 2019, because in September, the first warehouse receipt for these relevant cargoes was issued, and in January 2019 is when the fraud unraveled and everything went wrong at that point in time. Now, as far as the cargoes in question are concerned, there is a schedule at the end of my skeleton, which you'll see at tab 4, page 64F. There are 7 cargoes, 3 at the Zaplaski elevator, 1 at the Bilgorod elevator, and Zaplaski and Bilgorod were all corn. And then you have the Ismail elevators, 3 cargoes, 2 of which are wheat or feed wheat and wheat, and the other one is barley. And you can see the quantities concerned in the second column, the relevant purchase contracts to which each cargo relates, and also the warehouse receipts. And I'll take you to only some of those, not all of them, as we go through the submissions. And there are cross-references to the bundles within the table. Now, the policy itself, so it's a cargo policy, and you can see that in the core bundle at tab 19. And the relevant operative provisions start at page 304. So it's an open cover, and so it requires declarations to be made to the open cover, and in relation to goods not only in transit but also in storage, which is the case here. And you can see it's a cargo policy, not least because on the very first page it says marine cargo open policy, but the interest is described as on goods on page 304. And then on page 305 you have the classic cargo clauses, including institute cargo clauses. And at page 306, you'll see the reference to storage risks, and that's what we're concerned with in this case. But there are 2 other clauses which I ought to draw your attention to. The first one is at page 313. Which is the Fraudulent Documents Clause at the top of the page. I'll come back to this, so I won't read it, but this relates to one of Quadra's respondent's notices, or one of its respondent's notice points. And the other clause, which is worth looking at, is the Misappropriation Clause at page 316. Again, I won't read it out. Now, there was an argument between the parties at trial as to the nature of this policy. But Mr. Justice Butcher concluded in his judgment at page, so this is tab 8, page 127. Paragraph 64 to 66. I won't read it all, but Mr. Justice Butcher refers to the various features of the policy, including the interest clause. Paragraph 66, the learned judge concludes, consistently with what I have said above as to the subject matter of the insurance, I do not consider the policy covers a situation where no property has existed and thus has not been lost or damaged, and all risk marine cargo insurance does not ordinarily cover such a situation, though it can be extended to do so by clear terms. So what the judge was concluding is this is a property insurance. It's not a financial loss insurance of any sort. And therefore, that requires physical loss of or physical damage to goods. Now, my lords, there are 4 grounds of appeal. They're set out at paragraph 6 of my skeleton, which you'll see at tab 4, page 41. The first ground of appeal is as to the judge's decision that the goods to which the warehouse receipts related existed. That's a factual issue, my lords. The second concerns the identification of the goods. The third is whether or not there was an immediate right to possession. And the fourth are the practical consequences. And the practical consequences really are, they're more of a reality check against the conclusions which may be drawn as to the recoverability of any losses which may have occurred or which allegedly occurred under the policy in this case. Now, the third, if my clients succeed on the first or the second issue, we submit that the appeal ought to be allowed. The third issue is more limited in range, and I'll come back to where, in terms of its relevance, I'll come back to when it applies. But again, if it is relevant and we succeed on that, we say we also succeed. And then, of course, practical consequences, as I say, is something to take into account in relation.
If the judge was right on your grounds 1 and 2, in other words, that the goods existed, and that
Sufficiently identified.
they were sufficiently identified, and having paid for them gave you an insurable interest, then ground 3 doesn't help you, does it?
No, there would have to be
it was an alternative basis on which
exactly
to find insurable interest.
Yes, so as the third ground really only arises if we succeed on ground 2 in relation to advance payment but not right to possession, and then right to possession becomes relevant.
Yeah.
So it's quite a limited relevance, but it's still possible. But you're right, my lord.
Right.
Can I also put it the other way? If I succeed on the first or second ground, then the third ground doesn't become relevant in those circumstances either. Now, before I address those individual grounds, I just would make the position clear in relation to the law of insurable interest. And I actually, subject to the identification of goods point, I don't think there's a lot between the parties as to the law concerning insurable interest, but it's worth just exploring. Quadra has asserted an insurable interest in the goods, which were allegedly lost, by way of 3 matters, in no particular order. The first is that they had title to the goods themselves. Now, the judge rejected that argument, and I think there is a respondent's notice point in relation to that. The second is that they acquired an insurable interest by virtue of the fact that the warehouse receipts gave them an immediate right to possession. And the third is that they acquired an insurable interest because they made an advance payment for the purchase of these goods. And the judge accepted Quadra's argument on these latter 2 grounds. Now, our overriding point is that the goods, in order to sustain an insurable interest, first, they must exist, and I don't think there's any quarrel about that. But secondly, they must be sufficiently identifiable and identified in order to attach an insurable interest. Now, what do I mean by that? Well, one starts with the Section 5 of the Marine Insurance Act, which I'm afraid is not in the bundle separately, but it is set out in Mr. Justice Butcher's judgment. And I suspect my lords are well familiar with this provision, but still, it's worth looking at. And you'll see that at page 123 of the bundle, tab 8. So, paragraph 55, Mr. Justice Butcher sets out section 4, which I think we can ignore, and go to section 5, where you have the beginning. Section 500, I'm not really sure advances the matter very much. It says every person has an insurable interest who is interested in a marine adventure. And then you have in subsection 2, the provision in particular, a person is interested in a marine adventure where he stands in any legal or equitable relation to the adventure or to any insurable property at risk therein, in consequence of which he may benefit by the safety or due arrival of insurable property, or may be prejudiced by its loss or damage thereto, or by the detention thereof, or may incur a liability in respect thereof. So what that phrase really identifies is
that's a statutory enactment of the test in Lucina and Crawford.
It is, and I'll come back to Lucina and Crawford, if that's the right way to pronounce it, because it's Mr. Justice Lawrence's test. But the odd thing in that case, I always find this not amusing, but Mr. Justice Lawrence actually came to a decision that was no insurable interest in that case, and the House laws didn't accept that. But yet it's his test, which was subsequently adopted by Lord Blackburn and others in the late 19th century. But you're right, my lord. But what we say is what an insurable interest is really concerned with is on the one hand, the relationship between, on the one hand, the assured, Quadra, and on the other hand, the subject matter of the insurance. And in this case, to use the phrase in section 5.2, the insurable property. And you can see that, my lord, in the same judgment at the next page, where Mr. Justice Butcher quotes from the Feasy case. And I'm afraid the Feasy case is not in the authorities bundle, but we do have copies if the court would like.
He quotes it extensively in the relevant passages of.
He does.
They're quoted, aren't they, really?
What I think, what I'd just like to refer to, if I may, in Lord Justice Waller's judgment of paragraph 76, which is quoted, Lord Justice Waller identifies a number of different categories of cases. In group 1, you can see at the beginning of the quote, paragraph 57, are those cases where the court has defined the subject matter as an item of property, where the insurance is to recover the value of that property and where thus there must be an interest in the property for the assured to suffer loss which he can recover under the policy. Within this group are Lucena and Crawford. The subject was certain identified ships. The perils insured against were the loss of those ships. The commissioners had no interest, legal or equitable, in the ships, but a mere expectation. And then he goes on. And then he refers to Macaura, again, where there's a reference to the subject matter of the insurance being identified timber. And in group 2 cases concerned with life insurance, and in group 3 cases, concerns to other types of
Wilson and Jones.
exactly, and it continues, my lord, in the same vein. And you can see at paragraph 58 of the judge's judgment at page 126. Mr. Justice Butcher refers to Lord Justice Waller's judgment at paragraph 92, and he refers to the various principles. The first principle is from the terms of the policy that the subject of the insurance must be ascertained, and it's from all the surrounding circumstances that the nature of an insured's insurable interest must be discovered. So what we say is, and I don't think this is controversial, that of course an insurable interest is not dependent on there being an ownership or proprietary interest in the subject matter, and it may well go beyond possessory interest, and there are numerous cases which really explore this. But what is clear is that you have to have a subject matter, goods, which is sufficiently identified. So with that introduction, I'm going to go on to the first ground of appeal, which is the existence of goods, unless I can help my lords. Okay. And we can see, because it's I should also make clear that all the grounds of appeal which are being relied upon were permitted as an appeal by Mr. Justice Butcher himself, including the first ground, which is a factual ground. There was one, I would just call it incidental point, which was allowed by Lord Justice Mayles on an application to the Court of Appeal, but for the most part, all of this has been permitted pursuant to a permission granted by Mr. Justice Butcher. And of course, when we're dealing with the first ground, we are dealing with a factual ground. But what I would ask your lordships to recognise is, even though, and we set out the test for dealing with appeals from a decision of fact by the judge in paragraphs 20 to 22 of our skeleton, but I don't think that's controversial. Basically, we're looking for where the judge is plainly wrong, however you want to describe that, whether that means it's not supported by evidence or it's a decision which no rational judge would have come to, or however you like to test it. The key phrase is the judge must be plainly wrong. What I would say is it's striking that Mr. Justice Butcher felt that it was right to grant permission to appeal on this question of fact. And I do so for the reasons which I will develop in my submissions. Now,
What may have been beguiled by your advocacy, Mr. McDonald?
well, not sufficiently. Now, at paragraph 67 of the judgment, which you can see at page 128, you can see, my lord, paragraphs, this is the question being addressed by the judge, were there goods in the elevators corresponding to the warehouse receipts? And paragraph 70, Mr. Justice Butcher summarizes the material on which, or the evidence on which Quadra relied, and there are three items. The first were documentation issued by the elevators, which includes warehouse receipts and other documents. The second are the Bastico inspection reports. And the third are the Quadra's physical receipt of goods. And he then addresses each of these items in paragraph 71 to the end of the passage at 78, and concludes, as a result, that the goods in fact existed. Now, what I propose to do is just explore each of those three items of evidence and explain why the judge could not, I use this phrase advisedly, but I don't mean pejoratively, that he couldn't rationally support his decision, or at least he was plainly wrong in relying upon these items of evidence to come to the conclusion he did.
Just before you do that,
Yes.
is the question whether there were goods which corresponded to the description in the warehouse receipts, or is it whether they corresponded to the description in the contracts of sale, or is it whether they corresponded to the description in the declarations under the open cover?
Well, I think from my recollection, the declarations created a slight difficulties because some of them were entered after the event, but I think it's the warehouse receipts, because the contracts, the warehouse receipts are received, and they're the documents upon which the Quadra have relied to establish their insurable interest.
But the subject matter of the insurance was what was declared in the declarations to the open cover.
But the declarations, I think, correlate to the warehouse receipts.
And the descriptions were the same, were they?
Well, not as detailed, but you'll see.
That may matter.
We've seen one of the
matter some of your
We've seen one of
arguments.
the declarations.
Yes, you'll see them. If you've got the supplementary bundle,
Yeah.
it's the very last tab. And these declarations are not individual declarations. They're done on a sort of a bordereau basis, essentially.
Yeah. So tab 62.
Yeah, yes. So the very last, so you'll see at page 327. And the first page is, you'll see at the top of the page it says period November 18 to December 18. All that's, sorry, I beg your pardon. It's the storage declaration dated 30th of November 18. So it's basically looking at material in storage which are at risk. And there you have a number of declarations which set out, for example, the very first one is the Ismail elevator as one of the relevant elevators. And you can see there, and I think that it's the final two, which represent wheat and wheat, which are relevant for our purposes in this case. And you can see the entry date. It's got an insured value, entry date 16th and 26th of November 2018, no exit date. And I think you can pick it up again oh, sorry, I beg your pardon, I should just bring it to your attention. There is no reference to, on the next page at 328, you'll see reference to Zaplasky.
And also before that, Bilgerod,
Yes, Bilgerod, I beg your pardon, you're absolutely right. Bilgerod,
which is the one that we're concerned with. The
1,000.
1,000.
Yeah.
The last one.
Yeah.
And it's all four, is it, or the Zapatsky?
No, I think it's the first one and the second and the fourth, because the third one exited on the 5th of November.
Oh, they were the ones that were.
Yeah. And then next page you'll have the December declaration, or the end of December, the 1st of January 2019.
Yeah, and are we concerned with any of those?
Yeah, so the Ismail is it's not the corn, it's the two wheat.
Again.
you can see there, for example, my lord, although this is this was treated as an error at trial, which is the second one is actually identified as being exiting on the 26th of December. And then you've got Bilgerod, the 1,000 tons at the bottom of the page, and Zaplasky. You'll see the three relevant cargoes there.
And the Zaplatsky at the bottom of the three. Yeah, okay. So just bordereau for different year.
Yes,
months.
they are done in summary terms.
Different months.
Yeah, but I should make it clear, the way the claim was presented in the particular claim are done by reference to the warehouse receipts.
Sorry, what are done by reference?
By reference to the warehouse receipts. Receipts received by
What,
Quadra.
these bordereau?
Yeah, no, in the particulars of the claim, when the claim for an indemnity under the policy for the cargoes, it was done by reference to the warehouse receipts which were received as establishing the insurable interest. Because the
question was what was insured under the contract of insurance, and surely that's as set out in the declaration.
well, that's not the
Striking that there's nothing there about 2018 crop or third grade or anything of that kind.
That's true, but there is a contract. There is a I suspect, for example, if you look at Zaplasky, I'll have to ask my learned juniors to just check that. You'll see next to it a series of numbers.
Yeah.
And I think that's a reference to the contract numbers, the purchase contract numbers.
Okay.
Yeah, you can see they end with 7, 9,
7,
10,
which is
addendum
three addendum.
7, and then 9, 10, 10.
Yeah. So so it's not just a bare reference to corn or wheat or barley.
Mm-hmm.
It's cross-referring to the contracts, and as part of the contractual mechanism is the making of an advance payment, but also against a warehouse receipt. So if I could put it this way, I think it's too limiting to say, or too expansive to say, depending on your point of view, that the subject matter of the insurance is defined wholly by reference to the declaration because of this reference.
Yeah.
So now, when Mr. Justice Butcher went through the 3 items of evidence, he looked at the documents issued by the elevators. And remember, my lord, the elevators are the fraudsters in this case. The operators of the elevators were also the companies which either contracted to sell or to purchase goods with Quadra on particular occasions. And they're all part of the same organization. So the Agroinvest Group were at all material times in possession of any goods which may have existed. But what they were doing as part of the fraud is if they had goods, or even if they didn't, but they were selling these supposed goods 5 or 6 times to different people or buying them again. And in a sense, it was like a teaming and lading.
Well, it's a Ponzi scheme.
It's a Ponzi scheme, exactly that.
But it wasn't part of the fraud, at least as described in the evidence before the judge, that they were selling to multiple buyers non-existent goods. And that's the point the judge is making in relation to the warehouse receipts.
We certainly, our case was that it has to be proved that these goods existed. And it may well be that the goods didn't
It's a
exist.
different point. But it wasn't part of the fraud. You showed us the 2 paragraphs in 48, 49.
Yes.
And the evidence of your own witness. But it wasn't part of the fraud as alleged by your client. That the goods didn't exist at all. And that was the fraud.
Well,
Trying to sell people things that didn't exist.
well, I think they may, at the very lowest, there may have been goods, let's say 5,000 tons. Let's assume that, and for that they've issued numerous warehouse receipts.
Yeah.
So there could be a claim for 30,000 tons by 6 different traders, but all of whom are claiming that single 5,000 tons.
Yeah, but that's different from a fraud where there are no goods at all and you go on selling
Well,
non-existent goods to everybody?
Well, I'll come on to why I think the judge came to the wrong conclusion on the existence of the goods. But it may well be, for example, that once a warehouse receipt is issued for one set of goods, there's no other goods to which the warehouse receipt could relate. No other goods. Now, if I could ask my lords to look at...
Sorry to interrupt
Oh,
you
of
again.
course, no.
And was there any evidence or finding that this was a fraud which operated elevator by elevator, as opposed to simply across the entire Agroinvest estate?
I think my understanding is that it applied across all of their facilities. It was one company group who operated 10 facilities, and I think from memory, and I think that this is in Mr. Justice Butcher's judgment, I think there were claims for 270,000 tonnes of goods, and there were 27,000 tonnes remaining.
Yeah, my question was there a finding that it operated in respect of each facility, or simply that it operated across all 10 facilities?
I don't think it was that particular. I think there was evidence that the fraud operated against the whole group, which included these 3 facilities.
So
I
it's
can't speak-
consistent with the findings.
Yes.
In these particular elevators, there might have been enough for everybody. Even though across the estate as a whole there wasn't, by some 5 or 6 times.
It's very unlikely, my lord, given the finding, for example, there were claims for 18 traders were claiming 270,000 tonnes of goods when there were only 27,000 tonnes there.
Well, without knowing what the size was of all the various facilities, I have no idea whether that's a good submission or
But
not.
for example,
But so far as, we have to work on the basis of findings that were made. And I think what you're telling us is that the findings that were made about selling it over 5 or 6 times were by reference to the estate as a whole, not by reference to these particular elevators. Is that right?
yes, but certainly the state as a whole, what I think was clear from the evidence and was conceded at trial was that fraud affected these elevators as well. Whether they affected other elevators, I can't say. I mean, it's consistent with the fact, my lord, that there were no goods to satisfy all the warehouse receipts which are issued by the Agroinvest Group at these facilities. And I think, my lord, I'm just to make that good.
Well, the evidence which the judge refers to in 48 and 49 isn't, on the face of it, limited to these elevators.
I beg some. I'm sorry, I didn't hear that, my lord.
The evidence that the judge refers to in 48 and 49 isn't, on the face of it, limited to these elevators. Mr. Scott talks about stored in a number of elevators that the group owned throughout the Odessa region in southern Ukraine. So he's not focusing only on these elevators, but on the estate, as my lord put it.
Well, if I could take you to his judgment at paragraph, this is Mr. Justice Butcher's judgment in tab 4.
Yeah.
I didn't take it, I should have taken this earlier perhaps,
Yeah.
but you'll see it, page 118. You'll see the emergence of the fraud.
Yeah.
It begins, there is no doubt, and it was not an issue between the parties, that it was a fraud perpetrated by the Agroinvest companies, and that Quadra has been an innocent victim of that fraud. So the claim relates to the 3 facilities.
Yeah.
And to be a victim of the fraud, it must relate to those 3 facilities. But he then goes on to discuss the fraud, making it clear the precise details haven't been worked out. And then the next page, paragraph 36, the judge says, on the 4th of February 2019, a criminal investigation was initiated by the Ukrainian National Police. The National Police and the Ukrainian Grain Association held the first of a number of creditors' meetings on the 5th of February. And on the 7th of February, Agroinvest operations were blocked by detectives from the National Anti-Corruption Bureau of Ukraine. During the investigations conducted by the police, it was discovered that much of the documentary evidence had been destroyed or had disappeared. An exercise conducted by the Ukrainian Asset Recovery and Management Agency indicated that at the beginning of February 2019, some 27,000 tons of grain remained in 10 Agroinvest warehouses. This appears to have included some 1,475 tons of corn at Zaplasky, 377 tons of wheat at Ismail, and 629 tons of barley at the Ismail elevator. No corn was found to remain at the Bilgorod elevator. There are apparently mixed reports as to what has happened to the grain that had remained in the warehouses. It may be that it was sold by Armour via public auction or passed into the care of the National Agrarian Fund. It has not come to Quadra. On about 27th of March, Agri-Finance was placed into liquidation and dissolved. On the 15th of May, a further creditors' meeting was held, attended by the UCA, the Ukrainian police, and some affected traders. On this occasion, it was said that there were 18 trading companies affected by the fraud, claiming a loss of 276,000 metric tons of grain. And also, for what it's worth, my lord, paragraph 71 of the judgment. And when page 128, dealing with this issue as to were there goods in the elevators corresponding to the warehouse receipts? This is the first issue. And Mr. Justice Butcher says, paragraph 71, as to the first of the items of evidence, which is the documentation issued by the elevators, the defendant said that all these documents were unreliable because there was a fraud. That's us. I accept that there is a likelihood that the elevators issued warehouse receipts and supporting documentations to different traders in relation to the same physical grain. And then I'll come back to his conclusion, if I may, as I develop these submissions.
But the point the judge goes on to make is that it was the basis of the fraud. The same grain should have been sold several times over. It was integral to the fraud. There should have been grain in the warehouses which could be inspected on behalf of the traders. So
Yeah.
that's the point, that there was grain.
Well, the judge has
A
concluded,
whole load of people could have inspected and thought it was their grain.
but I say the judge is wrong to come to that conclusion.
Right, okay.
That's why I'm appealing against his decision.
Why is
And
it-
I do so not with a heavy heart, in the sense of I do it with a.
Well, you say he was wrong to say that was the essence of the fraud.
I say that that it has to be demonstrated that there were goods to which the warehouse receipts related. And I just want to explore each of the items of evidence which allowed the judge to come to the conclusion that there were such goods. But I make these submissions with, obviously a profound recognition of what I have to demonstrate to satisfy your lordships that the judge was wrong. So I don't want you to think that I do this lightly.
No, I understand.
Yeah.
But by defining the question in that way, you essentially dictate the answer, don't you?
I just put the question the way the judge put the question at his heading, and I don't mean to check. If I've changed it, I didn't mean to. You can see on the previous page 128 where there are goods in the elevators corresponding to the warehouse receipts.
Sorry, paragraph 69. I mean, he defined it. It's a slightly different. His question and his answer are different. 68 and 69 are not the same, are they?
Goods corresponding.
Well, I think you've got to read
descriptions
68 and
and cards.
69 together. I would submit.
Physically present.
I think you have to read 68 and 69 together, because he addresses the question whether the starting point was whether Quadra could show that there were goods in the various elevators of the type and quantity referred to in the receipts. And then he refers to...
I mean, he says that I consider Quadra succeeded on a balance of probabilities in showing that goods corresponding in quantity and description to the cargoes. What does the defined expression cargoes mean?
The cargoes refer to the goods referred to in the warehouse receipts.
Not as disclosed.
Not as declared, no.
Not as declared.
No. So if you look at the particulars of the claim, that's how they're defined. Now, my lords, I'm very happy to answer questions. I am championing the bit to actually explore each item of evidence, and unless, so the first item of evidence is the documents.
Sorry, but does the judge, anywhere, it looks as though he's using cargoes as a defined term in paragraph 69. Is that,
Let's have a look.
is that defined earlier in the judgment?
I think it should be. Well, yes, you can see paragraphs 18 and 19 on page 115.
Well, it's 18, isn't it, where he says, that,
so
he calls that the first Zaplasky cargo.
yes, so
He uses some cognate terms without prejudging whether and in what sense there exists a cargo.
yes, but so from 18 to 23, what he looks at 7 cargoes, and he then refers it to as the first Zaplasky cargo, for example, and he uses the same type of definition for each of the other cargoes, but you can see it's always by reference to the warehouse receipt. And I can only assume, therefore, when he says cargoes, he's referring collectively to the 7 defined cargoes.
Yeah.
Thank you.
So, my lords, the 3 items of evidence are, firstly, the documents issued by the elevators themselves, and that's, and also the second item is the inspection reports. And what I say is that these these documents are nothing. The inspection reports are very, very largely derivative of the information which was provided by the elevators, and don't provide any independent evidence.
Yeah.
Even though the judge said it, I think he described it in his judgment as the most important evidence. The third item is, of course, the fact that Quadra took delivery of other cargoes, not these cargoes, but other cargoes, at 2 relevant points in time, and I'll come back to that.
Mm-hmm.
So looking at the documents issued by the Agroinvestgroup, the first is the warehouse receipts themselves. Now, our point at trial, and again before your lordships, is that these are warehouse receipts issued by the fraudulent Agroinvestgroup, and you can see these documents. For example, the first one I would show you is at the supplementary bundle, tab 19. This is the first Zaplasky warehouse receipt, and it's signed and issued on behalf of the Agroinvestgroup, who is the owner of the facility, and they confirm that as of the particular date, 24th September, there are 5,000 tons of Ukrainian corn, crop 2018, stored at its warehouses, located at a particular address, and then it says quality as per the analysis card number 185. And my lords, you can see that analysis card at tab 30 of this bundle, which is page 244. And you can see it's card number 185 on the left-hand side at the top of the page. And you can see under the heading culture, it says corn 3 class, and you can see that repeated on the right-hand side. And then it has a number of specifications referred to. But you can see it's the name of the facility is Zaplasky, the loading, unloading point is AgriFinance, and the dispatcher is Quadra, as described, and the weight is 5,000 tons. Now, my lords, just going back to page 220 at tab 19, which is the receipt itself. These documents are issued by the warehouse, and on the evidence of fraud was that they may have been issued 5 or 6 times in relation to the same described goods. So when it says the goods are the property of Quadra, and if they're issuing the same receipt, just assuming there were goods of that description, to 5 other people, and they saying these are the property of another trader, and yet another trader, and yet another trader, they all can't be accurate statements. They can't all be truthful statements. They're not genuine. In the same way, on the same page, it says this is the only warehouse receipt issued for these goods at the bottom of the page. That cannot be a truthful statement. So this document really carries very little weight in terms of what it represents to be the case. Now, of course, it's a hard thing to demonstrate that there is a fraud or a fraudulent statement made by anyone. And in this case, it's accepted by the parties, both parties, that there was such a fraud of this particular nature. And if a fraudster makes a fraudulent statement on one occasion, it's not inherently improbable that he would make another fraudulent statement on another occasion, even in the same document. So as evidence of the existence of these goods, this doesn't count for very much.
Doesn't count for very much, or doesn't
Or
count
at
for
all.
anything.
Anything. I put it too high. It doesn't count for anything.
Are you saying that the document on page 244 is a fiction?
244, my lord. This is issued, well, it's issued by the same people.
Well, I know, but are you saying that there isn't 5,000, or there weren't, sorry, 5,000 tons, metric tons of grain with that level of impurity, spoiled grains, wild plants? In other words, was that a complete fiction? Or are you saying that there was 5,000, there were 5,000 tons answering this description, but the fraud is in the warehouse receipt being issued many times with a false statement that it was the only warehouse receipt issued for the goods?
I'm saying 2 things, if I may, and if I hope I'm not, I don't want to appear to dissemble, that's the last thing I want to do. But the first thing I say is that it hasn't been proved that there are goods to which aren't to the description either in the warehouse receipt or in the document 244, which I refer to. And the second point is if there are...
Simply because, as I understand the judge's findings as to what the fraud encompassed, it's quite possible that there were 5,000 tonnes. In fact, he finds that it's likely there were 5,000 tonnes answering the description, the chemical description, the impurities description in the warehouse, because there had to be something for somebody to see if they came and looked. The fraud is the old fraud of selling the thing many times over, or in this case, issuing warehouse receipts.
Well, I'm going to come back to so the only time anyone looked at these things were the inspectors.
Yeah.
And that's the second element of evidence I'm going to come back to.
But it doesn't logically follow from the fact that there was a fraud, that both of these documents are false in every respect.
Well, I'd say it hasn't been proved that the goods answering the descriptions in either of those documents has been established. It hasn't been proved that's the case.
Well, the judge, this is part of the problem with respect, that it's sort of picking off each point in turn as opposed to looking at it, as the modern word is, holistically, because, which is what the judge did, really. I mean, the judge says this doesn't prove very much, is really what the judge says. It goes some way, because really the point my lord's just put to you, if it wasn't being said, the fraud is, there never were any goods at all of this description, because there were goods in the warehouse which were inspected, and the judge says that those goods, on a balance of probabilities, were goods of this description, because if they hadn't been, somebody, maybe not these inspectors, but SGS or somebody else who conducted a proper sampling process, would have discovered that what they had, for example, was 2 inches of 2018 corn and then sawdust underneath it. Well, that's the point the judge is making.
Well, and obviously what I'm trying to do is say the judge is wrong, and the judge is, and I'm prepared to look at it holistically as well as each item of evidence individually, so I don't want you to think that I'm concerned about the holistic presentation of the evidence. I never say that. But what I would say is, insofar as the judge is relying upon the inspection reports, which he does describe as the most important evidence, he's wrong to do so for two reasons. And I will come back to it. The first is there were major limitations in what those inspection reports actually revealed. And that was explored with the witnesses, and I'll take you to the evidence. It's clear what the witnesses are saying. But essentially, the inspectors said that by a visual inspection alone, what they couldn't tell, whether these goods, for example, are the property of Quadra, which is self-evident. But secondly, they couldn't tell what the grade, which is the quality, what the crop year is. And they couldn't even tell the quantity, because all they saw was the surface layer. And all they did was use a laser meter. But they don't know what was under the surface layer.
I think my question was just going back to your proposition, which you I think, when you agreed with Lord Justice Popplewell, when you said that this is a fraudulent operation, if you like, this group operated in a fraudulent way, therefore you can't place any reliance on any document that they produce.
I do say that.
Well, I know you say that, and I'm just wanting to test whether that's too broad. I mean, just as a matter of common sense, if there's a fraud, you involve as few people as possible, because otherwise it's a sad risk of going wrong.
I've made that submission before the criminal court. It doesn't always work.
I mean, it follows from your submission that the laboratory assistant, NS Zebrina, if that's the way to pronounce it, was in on the fraud, as well as Mr. or Miss Valentin Perron, who signed the warehouse receipt, or affixed the seal to the warehouse receipt. I just question whether that is something we should just sort of can take from your proposition that there's a fraud here. That the fraud can perfectly well operate. I mean, you may come back and demonstrate why I'm wrong, but it's perfectly possible to have goods which exist, but the fraud is in issuing multiple warehouse receipts.
My lord, as to the individuals, my lord, there was evidence before a trial which goes into the details of who the individuals were, but that wasn't really the point of trial. The point was that there was a fraud affecting the entire operation. But the way I want to put this is this: if it weren't for the inspection report, let's put it that way, I would suggest that the judge would not have, or could not rationally have relied upon the warehouse receipts alone as evidence of the existence of the goods, which correlate or correspond to the description in the warehouse receipts. So it was the inspection reports which, if you like, carried him over the line. And I say he was wrong to do that for two reasons.
And by warehouse receipts, you include the analytical sample as
yes,
well?
because it's referred to in the document. Because it's referred, so you can see under the heading quality, as per the analysis card.
Yes, I know.
Yeah.
But are you saying, therefore, that the lab assistant who prepared that document must have been in on the fraud?
I would say that, well, I haven't got the details of the individuals involved.
No, but I mean, that's the point, you see, because it's the point my lord's putting to you, is that some laboratory assistants prepared that sample, whatever it's called, sample card, analysis card, and on the face of it, hasn't done so out, as it were, in thin air, unless that person was party to the fraud.
Well, it's very difficult to see. I would say the probabilities are yes, because it's very difficult to see that how, when there are a fraud of this nature, suffuses the entire operation, and you have numerous warehouse receipts being issued.
But let's be realistic about this, Mr. Popplewell, because a laboratory assistant will not have been testing 5,000 tonnes of corn. It will have been a sample,
Correct.
taken from a silo. So he or she would be given a sample from the silo.
Correct.
And no doubt whoever was behind the fraud would have made sure that they were given a whole load of different samples for the 18 different
That's very fair, my lord.
victims of the fraud.
It's very fair, and accept, but of course a sample, I mean, it could be a sample drawn from anywhere. There may have only been half a ton, and you can take a ton. It doesn't mean it's 5,000 tons.
No, I follow that.
And if it's just a sample, it will only tell you what that sample's quality constituents are. So even if that were right, and there was a particular employee issuing a particular document who was acting entirely honestly, others within the organisation may have misfed that assistant false information, such as this is a sample from 5,000 tons, whereas it may not have been.
Which, I mean, you're perfectly entitled to make that submission on the basis, not least, for example, that there is no surname, signature for who collected the sample. I mean, it's just a sample that
Correct.
somebody has tested.
Correct.
But I was actually going it from the other end, which is just, your submission did appear to be as broad as, this was a fraudulent group. And in fact, it's a group of companies, each warehouse or silo, call it what you will, each facility is operated by a separate corporate entity within the group, as I understand it. The Elevator is the name of the company, the LLC that owns the facility. But your proposition was as broad as saying that every document that is produced by the fraudulent group or by any person within it must be given no weight.
Let me put it this way, if I may, is just looking at, and I haven't got onto the inspection reports yet, and I shall, but looking at the warehouse receipt, this is the document which is the very heart of the fraud. There are numerous warehouse receipts issued to various traders relating nominally to the same goods. So it's very hard to see, if you can excuse other documents, administrative documents within the facility, this is the document which actually allows the mechanism of fraud to work. And therefore, this must self-evidently contain untruths. And I've identified two.
Well, no, I'm not sure it does. I mean, for example, do we actually have one of the other warehouse receipts issued to another party in respect of the same crop, in respect of the same goods?
No, we don't.
I mean, the fraud could be that, in essence, you've got a test sample, which is on analysis card number 185.
Yeah.
And the fraud is that you have two warehouse receipts in identical terms, but one referring to Quadra and the other referring to somebody else, each saying this is the only receipt issued in respect of these
Correct.
goods.
Yes. But that would be untrue.
Well, but some of it would be untrue. The bit that would be untrue is this is the only warehouse receipt relating to these goods. What is not necessarily untrue is that there are no goods.
Well,
what is not necessarily untrue is the statement that there are goods.
Yes. So my point is I don't want
Somebody
to
sampled something, didn't they?
Yeah, but they could have sampled. We don't know what they sampled, and we don't know how big
Well,
or
we do
small.
know
it was.
from page 244 that
Yes.
what they purported to have sampled was the 5,000.
That's what it
Ton
says.
lot.
That's what it says. But I think, and I don't want to overcomplicate my submissions, but the simple point is, and my lords will either accept it or they won't, but my simple point is that this document, which is used as part of the fraudulent operation itself, contains, I would say self-evidently, at least two statements which are untrue, bearing in mind there are a number of warehouse receipts issued to multiple traders.
The document at 220 may. My questions throughout have been directed about whether you can equally say the same in relation to the document about at 244.
Well, my submission is that if there are fraudulent statements in at least two instances in the warehouse receipt, then it's likely, or at least it's not improbable, that there are other false statements in that document.
Well, you have to put it rather higher than that, don't you?
But
You have to say that the judge would be bound to find that there were false
What?
statements there because he wasn't entitled to place any weight on these for the purposes of deciding whether goods of this description were there.
I would say that the judge could not have put any, if this was the only evidence and no other evidence, no inspection reports, I would say the judge really could not rely on these documents by themselves. Because but as far as my Lord's Snowden's question about the analysis card, that if it is genuine, it can only go so far, because it's only dealing with something which is very minor and it doesn't really tell you what the analyst was looking at. And so, my lords, there are, and I'm going to move on. I'm happy to answer your questions, of course.
No,
but,
okay.
Yeah.
Sorry, we're asking you rather a lot of questions.
No, and they're thought-provoking and interesting, and I'm happy to answer them. But I'm conscious of time. It's not a criticism, but I'm happy to answer them. The second point I would like to make, though, is it's not just this document which is issued. There are also, when the inspectors go along to the facility provides them with an additional document, which you'll see, for example, at tab 31. There are two documents. One's a letter and one is an account book. At page 245, you'll see there's the letter. This again relates to the same cargo. And we inform you that as of 8th of October, corn is stored at the granary of Zaplasky, located at the address, which is 3 corn, which is grade 3 corn, stored 5,000 tons, owned by Quadra. And you'll see that there's another document which is called the Form 36 accounts at page 246 on the next page, and you've got the same statement. So here, this document is nothing more than a document issued by the very same persons who issued, when I say persons, the corporate persons who issued the warehouse receipt. And it adds nothing to what as evidence to the receipt itself. Now, my lords, it's worth just looking at the judgment. When I come on to the inspections, and I could take you through the other warehouse receipts, but they're all basically in the same form. I think it's fair to say, however, that the Ismail receipts don't have a reference to, and I can show you just an example. If you look at tab 22, page 223, you'll see it doesn't refer to a grade. This is Ismail. It's for 4,750 tons of Ukrainian feed crop, 2018, stored in this particular warehouse. Again, said to be the property of Quadra. This is the only warehouse receipt issued for these goods. Now, there's no reference to grade, but the Ukrainian feed crop wheat is a description of the cargo, which has its own specifications. But if I can go on to the inspection reports themselves, and for this purpose, it's probably just worth reminding what the judge found in relation to the inspections. And you can see that at Core Bundle, tab 8, page 121.
Page 121.
121. The judge refers to the evidence of Ms. Natalie Gonchar and Mr. Alexander Gonchar, who are both Bastico inspectors. Mr. Alexander was the actual inspector who went to at least see some of the goods. And Ms. Natalie Gonchar prepared the report, so she didn't actually attend. At paragraph 3 on that page, Mr. Justice Butcher says the inspections consisted of the inspector being shown a letter from the elevator declaring the quantity and quality of the cargo stored on behalf of Bastico's client, in this case Quadra, and a corresponding account book, Form 36. They're the documents I've just taken you to. The inspector was then shown grain which was said by the elevator to include the grain referred to in those documents. And then paragraph 6, you can see the inspections. I beg you should look at paragraph 4. The inspector would examine the grain shown. Certainly in the case of the inspections carried out by Mr. Gonchar, this involved a visual inspection from a viewing gallery at the upper level of the elevator. What was shown was a commingled bulk of grain. Quadra's grain was not segregated, and the total amount of the grain in the elevator was larger than the amount said to be Quadra's. The inspector did not take samples. It was not possible for the inspector to ascertain the quality of the grain. What the inspector did do was to use a laser meter in order to determine the volume of grain in the elevator. The inspector did not examine whether the grain below the top layer, which he could see, was the same. Mr. Gonchar did, however, consider it unlikely the elevators had a false bottom. The inspections would take about 3 hours and were carried out during daylight hours. Once the inspections had been completed, the inspector would give the resulting information to Ms. Gonchar, who would draw up the inspection report. Ms. Gonchar herself did not attend the elevators. In the reports, the identification of the silos at an elevator in which the relevant goods were located came from information which was provided by the elevator. Each of the Bastico inspection reports bore a statement that Bastico did not guarantee or make any representations about the accuracy and authenticity of all the documents submitted to it, the ownership of and title to the goods, quantity and quality of the goods. So the question is, actually, what value does the inspection reports actually provide, given the limitations? Because even when it comes to the one thing you could think they could verify is quantity, what the judge says is the total amount they've shown is greater, but all they're looking at is the surface level. They use a laser meter. They don't know what's beneath. And this is a facility which mixes and contains different cargoes at different times, different grades, different commodities, and they're moved around.
But was there evidence that they were in any one silo? They were mixing 2 different grades of grain from different years or anything like that?
No, the closest it got, my lord, was that there was one silo where it contains a particular type of grain on one day, on another day it would contain another type of grain, but no, I can't say that.
And why would they mix them? I mean, these are cargoes which they're intending physically to deliver to someone, and one would have thought that it would be very soon discovered.
Yeah, but the problem is if you don't... sorry,
different grains mixed in these fluid products.
The difficulty is, of course, if you can only see the surface, you don't know how deep it is. You're using a laser meter to make...
The laser meter informed them that whatever it was filled the silo, and it didn't have a false bottom.
I mean, there are 2 possibilities you're positing because of the limitations. One is that underneath what was seen on the surface, there was a different quality of grain, different type of grain. The other is that there was a false bottom, and therefore the visual...
I'm not pushing the false... I'm not saying there was a false bottom.
So your challenge to quantity and I think quality is on the assumption that there could, as a matter of inherent likelihood, have been a different quality of grain underneath the surface of what the inspector looked at. Is that right?
Yes, but the inspector's evidence, and I think the judge reports that with the visual inspection undertaken by the inspector, who did not take a sample, could not tell what the quality was, the grade, nor could he tell what the crop year was. So the only thing which he has any means of identifying is saying whether it's in generic terms corn, wheat or barley, and with the help of a laser meter, identify possibly the quantity, or even though that's got limitations. But in relation to other aspects of the description of the goods referred to in the warehouse receipt, he has no means of doing it, and that was the evidence of both these inspectors.
But I think, my lord, the point my lord is putting to you is that this is a very unlikely way to run a fraud. At some point, you're going to have a number of people coming to say, give me my quantity of 2018 grade 3 corn. If you've mixed in your silo corn from different years or different grades, how are you ever going to fulfill that order? Because the person taking delivery will know, because they will be able to test whether what they've been given is grade 3, grade 2, grade 1 or whatever. And if you just mixed it all up in a particular silo, how on earth do you avoid detection when you actually have to deliver to people.
But my lord, I think that's the problem, because in this case, the fraud, that fraud works until it stops.
Well, I know, but the point is it had been working. In other words, I mean, nobody's suggesting this fraud happened with one cargo. It had been going on for a time. But my lord is putting to us, I think the point is that if you're running a successful fraud for a bit until it's discovered, the one thing you wouldn't do is to mix grains of different qualities so that you couldn't actually fulfill any orders and you would be detected virtually straight away.
There was, before the court, there was only evidence of two reports, two inspectors who actually took I'll take you to those, who took a sample.
What the inspectors could take samples of while the grain is in the silo is a different question. I think my lord was putting to the point, you wouldn't be a very good fraudster if you mixed grains in different silos, because you would actually mean that you'd never be able to deliver genuine cargoes to people, and you'd be detected pretty much straight away.
My lord, I'm not asserting there was evidence that they were mixed. I'm not asserting that. But what I am saying is, if for example, the inspectors were shown not a 2018 year, but 2017 year, grade 6 corn cargo, they have no means of knowing whether that does or does not comply or correspond to the description of the warehouse receipt. Yes, in one sense, I mean, if you're a fraudster, you do what you need to keep the fraud going. But if no one's going to take samples, and the Quadra inspectors, or the Bastico inspectors, did not take samples.
But other people did.
Well, we only have
We know that there was an SGS
they're the only.
sample taken and a Bureau Veritas sample taken.
Yeah, but no, I don't think Bureau Veritas. I think it was two SGS.
All right, two SGS
But that
samples,
was
which did not disclose that what was in the silos in those cases was something different from what their clients had been told they were getting.
That's true. Although
So going back to your 2017 point, I mean, there's no evidence that there was any 2017 corn in these evidence.
no, but there is evidence that it was grade 6 and grade 3 cargo.
Well, I've got the two different grades. Yes, I follow that point. But it was all 18 cargo.
But what's striking about the SGS reports is that they were done on the instructions. So the client of SGS on that particular occasion was the Agroinvestgroup, Agrifinance. So whereas Bastico was instructed by Quadra, who were not involved in the fraud, the two SGS reports, for whatever reason, were done on the instructions of Agrifinance for on sale to other entities.
But are you suggesting SGS were party to the fraud?
Of course not. No, I'm not suggesting
You
that.
have to take it as read that what they inspected
No, but they would have
found
been.
is what they found.
What I'm saying is they would have been instructed to take samples. They wouldn't have done it without instructions.
Maybe
But
not.
I'm certainly not suggesting SGS were guilty of
Might
fraud.
have been their standard operational practice to always take samples.
Well, if you're running a fraud with Quadra, against Quadra, the one thing which the Bastico inspectors have not done is taken samples. They never took samples. And all you need to sorry.
Yeah,
I'm sorry. No, go ahead.
Just looking at the middle of paragraph 47.4, I understand the statement that the inspector didn't take samples. That's just a fact. He either did or didn't. And he said it was not possible for the inspector to ascertain the quality of the grain. That might follow from the fact that he didn't take samples. Is it impossible for an inspector to take samples?
No.
So you're running this fraudulent operation. You know that at any time somebody may come and insist on taking samples. And you know you have to deliver grain of a certain year and quality at bare minimum because people come and ask for it. So on what you want to keep the fraud going, isn't it more likely, in fact I think as the judge found, that you would have grain of a particular year and quality separate from grain of a different year and quality in different silos? You run that organisation properly. The fraud is in issuing multiple warehouse receipts. For the goods are there though. Goods answering the description in the warehouse receipts you issue are there. The fraud is just issuing more than one warehouse receipt.
Well, the way I put it is that the only evidence that these goods corresponded to the description of in the warehouse receipts are the warehouse receipts. The evidence of the inspector adds very little, if anything, because all it really does is indicate that they saw a cargo which they can describe as corn, wheat, or barley, and the quantity, at least from a surface perspective, matches what their expectations were, or at least it may be in excess of what their expectations were. But when it comes to other elements of the description, which includes the fact that these were goods belonging to Quadra, secondly, that they were a particular grade and a particular crop year, that's something which the inspectors could not testify to.
Was there any evidence of the practices in relation to
There was no
different
no
crop
evidence.
years? I mean, I don't know enough about this. I just feel inherently surprised at the idea that they would still have any 2017 or earlier corn available, especially when the fraud involved them being short of space, as it were, and selling the same over and over again. So
Much easier to sell 17 as 18.
I can't say. There's no evidence of
no
money.
evidence, right?
Is that a convenient moment to have?
Yeah, I think it is. I'm sorry, I've taken up too much time.
We'll say 5 minutes.
5 minutes.
Got rice? Because he has to reset it from his side. So whenever we turn it on, we have to tell him. Before what? So after, well, we just tell him that Ross, listen, it's going to be taking more than 15 minutes, 30 minutes break. So I need to turn it off so that you can reset it to make the come back when I turn it on again.
So when we're going to take back the camera, we're going to change it.
Let's find out.
Oh, I thought you said it was zoomed in.
I don't know how to
I want to check.
That's this.
I think this one's down.
I think 3, so that they can see all of them better, isn't it? Yeah. But then it's going to show us.
I know. Only one is missing.
My Lord, I want to just make a few additional points on this first ground of appeal. What I would say is there are limitations in the inspection reports. They're reflected in the evidence of the inspectors themselves. They're referred to at paragraph 30 of our skeleton, and the transcripts are at tab 9 of the supplementary bundle. I don't think there's any need to go through it, but the gist of it is captured by...
Paragraph 30 of your trial skeleton?
No, of the appeal skeleton.
Right.
3-0.
Okay.
And you can see it, supplementary bundle tab 9. You will see reference to the transcripts in question, but the gist of it's captured by the judge in paragraph 47 of his judgment. But what the point is, of course, is what could actually be determined by a visual assessment or inspection by the inspector is very limited. And the information which was included in the inspection reports themselves, I short to show you just an inspection report, as you can see.
But you're not saying that anything that the judge found in paragraph 47 is factually incorrect?
No, I actually rely on it, if I can put it that way. And my lords, for example, you can see an inspection report, just to take, I mean, no particular one, but at 38, just for your reference, you can see what the inspection report looked like.
Tab 38.
Tab 38.
Well, the one, actually, but the one that relates to the documents you did show us at 2.
Oh, right, that's
is the one under the next tab, isn't it? Tab 32.
I'm so sorry, 32, you're absolutely right.
Sorry, which tab?
32.
32.
Yeah. So you can see there, my lords, that there's a reference to 5,000 tonnes of grade 3 corn stored at Zaplaski on account of Quadra. You can see that sort of 2/3 way down the page. You can see reference about, again, halfway, just before the hole punch, it says on the 8th of October, Bastica, Ukraine, inspected proceeded to the appointed complex for the inspection of the elevator's documents and the visual assessment of the stock. So it's making it clear it's only a visual inspection and nothing more. And then there is, it says, according to the letter, which is the document I referred to, this is what's held. According to the account book, this is what's held. And it just says, based on measurement of grain silo of Zaplasky elevator, is as follows. And then you've got those reports. And you can see, just for the sake of completeness, at page 248, in the fine print, as it were, in the second paragraph, it says, Bastico Ukraine does not guarantee nor make any representations about the matters which follow, which include ownership and title, quantity and quality. So, they're the inspection reports. And we say, therefore, because there's so much reliance on documents obtained from the warehouse themselves, which are themselves questionable, and very limited information, if any, is obtained by the inspector's own inspection, they aren't a safe item of evidence from which the judge could have come to his conclusion. Now, before I get to the third item of evidence, very briefly, when it came to the third Ismail cargo, there was no inspection. And for this purpose, therefore, the judge relied upon two other inspections. One was in relation to a cargo of barley, and the third Ismail cargo was barley. One was in relation to, now I should make it clear, this third Ismail report, certificate was issued just as the fraud was unraveling.
Is this the SGS report?
No, that's what the report my Lord, Mr. Justice Butcher relied upon. And I'll come back to that. But just looking at the warehouse receipt itself, which you can see at tab 25 of the bundle, of the supplementary bundle.
So I was looking at something else. Give me the number again. I'm so sorry. It's my fault.
No, so it's tab 25 of the supplementary bundle, my Lord.
Yeah.
So this was issued on 16th of January 2019. And if you look, don't need to take you to it, but paragraph 35 of Mr. Justice Butcher's judgment, he explains when the fraud started to emerge. And this is when all the red signals and alarms.
What was the date when they turned up and they weren't allowed in? Was that the 16th?
Well, I should take you to the judgment rather than speak from memory. So it's paragraph 35 of the judgment. So you can see at page 118, in mid to late January, Agroinvestgroup's offices became difficult to contact. Mr. Kavirkin of Quadra found that his main contact at Agroinvestgroup stopped taking his calls around the 14th to 16th of January. When he visited the offices on the 17th of January, he found them closed. By late January, it seems that news was circulating that Agroinvestgroup might be in trouble. And on the 31st of January, it was reported the group was on the verge of bankruptcy. At about that time, a number of traders, including, as I've already set out, Quadra, attempted to gain access to Agroinvestgroup. And you can see in the last sentence, on about the 1st of February, two leading figures fled Ukraine. Now, my Lord, Mr. Justice Butcher, relied upon, because there was no inspection of the third Ismail cargo, he relied on two other factors to demonstrate that the goods actually existed. And there were two reports. One report was the SGS report, which my Lord Chancellor referred to. And yeah, that's at tab 60, 60 of the supplementary bundle. Now this is for 5,000 tons of barley. This inspection was on the 7th of December, so it was 40 days before the warehouse receipt was issued. And I think it's common ground that the fraud was underway by this time. And indeed, you can. What's also interesting is if one goes to, in the same bundle, to tab 5. This was Quadra's closing submissions at trial. And what was, you can see it, footnote 76. So page 128. So this is Quadra's closing submissions. There is evidence that the fraud was underway by the 7th of December. On that date, SGS attended the Ismail warehouse in order to inspect quantities of feed, wheat and barley sold by Agrifinance. So Agri is part of the Agroinvest Group, to Amias. And as the Hammer and Van Hussen report, which is not before your lordships, the very same SGS inspection reports were then presented by Agrifinance to Arcadia. So at this juncture, they're presenting the same report to two different entities in relation to the same cargo. And my lord relied upon, Mr. Justice Butcher relied upon this as evidence that the third Ismail cargo existed 40 days later. And we say, firstly, it's too early. Secondly, there were obviously by this stage multiple claims on this cargo. And thirdly, the fraud wasn't emerging at this juncture where it was emerging on the 16th of January when the warehouse receipt was issued.
But we've jumped from tab 60, where we're looking at an SGS report of the 2nd of January, to an earlier SGS report of the 7th of December, haven't we? This footnote. The one we were looking at, you told us was dated the 2nd of January.
Sorry, if you look at the date on 321, it says 10th of December.
Oh, I misunderstood what you said.
Sorry, I didn't mean to suggest.
So is this the same report that's being referred to at tab footnote 76?
It's got an inspection date of the 7th of December.
So the report is the 10th and the inspection date is the 10th.
Right.
So this is 40 days before.
Yeah, I follow.
Yeah.
Okay, thank you.
And so these inspectors, just to go back a point, these inspectors actually did physically look at what was there. They did sample what was
They
in.
did. No, I accept that.
Even though they, because in fact you can see them doing it at page 320.
Yeah, but you may remember, my lord, this is where I said that they're actually doing it on the instructions of Agrifinance.
Never mind whose instructions they were, they physically inspected the cargo and there's some photographs on it.
I don't think I've ever disputed that, my lord.
So
I've never said they didn't do it. I accept that they did.
So if we go back to the point about how do you conduct a good fraud in relation to this, you know that presumably at some point it is possible for an inspector not instructed by the fraudulent group but by somebody else might come and say, can I just do a quick sample like this?
I would submit that if you know that they're not going to take a sample, then you don't have to worry about that. Because, for example, the number of times Quadra had instructed Bastico to...
Quadra's inspectors might not, but can you base a fraud upon the proposition that nobody who you are defrauding by the issue of multiple warehouse receipts is ever going to have an inspector who's switched on enough to come and say, can I just take a view going
Well, all I can say, my lord, is the only evidence we saw of sample being taken was SGS on 2 occasions. That's all I can say.
Well, they say, don't they, on page 320, they conducted, representative sampling performed from the conveyor belt during partial movement of a cargo of about 200 tonnes. identify the bins as per GAFTA 124 rules. So that seems to be sampling pursuant to one of the GAFTA forms.
Correct.
And
I accept everything. I'm not challenging what
well, I'm
SGS
certainly making the point, Mr.
Yes.
Vegas, which I think the judge had well in mind. That,
Yes.
okay, these particular inspectors didn't sample, but sampling is, pretty standard
Well,
in this trade.
I don't know. I don't know if the evidence supported the notion that whether something was or was not common in relation to these facilities at this time. All we have is 2 reports. All the other reports we've seen were not based on samples.
Right.
So, my lord, I should just correct. I made a misstatement earlier when I said that Mr. Scott was an inspector instructed by my clients. It's true in relation to some clients, not others, but in relation to another claim, not in relation to this claim. So it was a claim by Suntrade. And I'll come on to Suntrade in a moment.
Well, but I mean,
I just want to correct that in case. Now, my lord, I just want to locate where I am because I've dealt with the inspection reports and I'm dealing with the third Ismail, which was not the subject of an inspection.
yeah.
And Mr. Justice Butcher's basically satisfied himself that there were goods to which the warehouse receipt related, or at least corresponded,
Yeah.
by reference to the SGS report. And I say, well, that doesn't provide much evidence. And the other report he relied upon was at tab, sorry, I beg pardon, the tab 61, I think it is, or 62, 61. Now, this is done on the 22nd of January, so this is 6 days after the warehouse receipt. And again, it's for Suntrade, so this is the other commodity trade I referred to. And on this occasion, Bureau Veritas didn't take a sample. You can tell because it refers only to a visual inspection, a visual assessment, plus documentary verification. So it's the same type of inspection, which was carried out by Bastico on behalf of Quadra. And you can see at page 323, there's a description of the cargo, which is barley, third class, 5,000 tons. The amount of the cargo actually measured or visually. And then, so it doesn't actually make clear what was being done, but you can identify all the bin numbers, which was referred to or so identified by Bureau Veritas. Whereas with Bastico, bin numbers, at least in relation to the ones we've seen, I think there are others which may be different, weren't identified. So we say that these 2 documents by themselves don't demonstrate that were in fact goods which correlated to the description in the third Ismail receipt, not least because it actually says these are goods held for the account of Quadra. And these are the goods we're looking at are either Suntrade or agri-finance. Now, the final element of the evidence, which I want to take very briefly, is the fact that Quadra had said that they accepted delivery of 2 other consignments, which are not the subject of the claim. And that's dealt with, you can see them summarized, my lord, in Quadra's closing in the supplementary bundle of tab 5. Paragraph 74. Sorry, I've got that. Page 127, I'm sorry. And you can see it's 74, 1 and 2. There were 2 deliveries said to have been taken by Quadra The first was on the 5th of November 2018, which was 7,000 tonnes of corn at Bilgorod. Now, firstly, the only evidence in support of this was a declaration, which was, you can see, referred to in footnote 72, which was made by Quadra in respect of 3,000 tonnes stored at Bilgorod. So and then of course it refers to 7,000 tonnes there. Oh, beg your pardon. And 3,000 tonnes have been stored at the Bilgorod since 9th of October, it says. Now, what's obviously interesting is that this only relates to Bilgorod, and there was only 1,000 of the claim, only 1,000 tonnes relates to Bilgorod. This is not evidence of anything which may have happened at Zaplasky or Ismail. And for that, of course, you've got at 74.2 another delivery referred to, which is 800 tonnes.
Well, hang on a moment, before we move from
Yes.
74.1. What they say there is they took physical delivery of 7,000 tonnes of third grade, purchased, etc.
Yeah.
3,000 of which have been stored at the Bilgorod warehouse since the 9th of October.
Yes.
And there's a documentary reference there. Well, if that's correct, then what they go on to say must be right, mustn't it? That as at the 2nd of November, when the warehouse receipt was issued, there must have been 1,000 tonnes of corn there.
Well, the only evidence of this was a declaration made to the insurers under the policy, nothing else. And that was it.
What's H4?
And the declaration was made
152.2?
sometime. I beg your pardon, my lord?
What is H4 152.2?
That's the addendum 8, which is just the contract which they entered into.
So where does the information that there are 3,000 of it have been stored at the warehouse?
I think it's, if you look at footnote 72, you can see reference to the declaration. I don't think there's any independent evidence of that.
So just what they declared to your client?
Correct. I stand to be corrected if I'm wrong.
So it would be pretty odd to declare something that wasn't there.
Yeah, it was a year later, for what it's worth, but I'm happy to be corrected. But in relation to the second item, is I'm sorry, my lord, if you want to move, unless you want to.
Just
Well, the declaration.
the judge relied on this, didn't he?
He did, as a third item of evidence.
He relied on the fact that there was evidence that there had been 3,000 tonnes in October, from which he followed that there must have been corn in there when the warehouse receipt was issued.
So I've just been told, I'm sorry, I may have misrepresented the position. There's a warehouse receipt at tab 28, page 235 for this on the 9th of October.
Right.
But I think what the point I was making is that the declaration, there's no evidence of there's what's said at paragraph 141 is the claimant took delivery of 7,000 tonnes pursuant to this contract, but 3,000 tonnes of this have been stored since 9th of October. It's obvious that 1,000 tonnes must have been physically present on the 2nd of November. Anyway, we say as far as that goes, it's obviously not this not the cargoes we're concerned with, it's other cargo for what that's worth. But the second item is a similar item. But, sorry, the main point, of course, is this is just Bilgorod. It's not Zaplasky, it's not Ismail. And altogether, there are, as far as corn is concerned, there's 14,000 tonnes of corn claimed, all but 1,000 of which is held at Zaplasky. Only 1,000 tonnes is held at Bilgorod, as far as the claim is concerned. And when it comes to the second item, 74.2, we've got 800 tonnes delivered from the Zaplasky warehouse in 2019. But of course, that's just 800 tonnes. And and it's a Pulaski warehouse where it's supposed to be 14,000 tons. Or 13,000 tons, sorry. And of course, there's no deliveries at Ismail. And what we don't know we have is, whilst they may have been stored, we haven't got independent evidence of the actual delivery. Although I think there may be railway wagon receipts in relation to, I'm not sure in relation to this 800 tons, but not the 7,000 tons. All right, my lord. So that's the first ground of appeal. Right. I'm going to move on. But I think there are a couple of respondents' notice points, but one in particular, which is as to the burden of proof and how it shifts.
Just before you move on to that, sorry to hold you up.
No.
The comparison we're doing in relation to quality, you say it's necessary to establish that there was physically present the right kind of grain, corn, wheat, barley, the year of the crop, and the grade. Anything else?
Well, for being held for the account of Quadra, because that's what this receipt says, as opposed to another trader.
I'm not sure I understand that.
Well, if it's not being held, if
No, this is on quality. So just on quality, not anything else.
Oh, I'm
just
so sorry.
quality. My lord's putting it to you that it's corn rather than something else, that it's 2018, and that it's grade 3.
Correct. Sorry, I'm sorry. I thought you meant items of description.
But nothing more than that, because it did seem from your skeleton you were suggesting it had to be of the contractual quality.
It has to be at least it has to be the quality referred to in the warehouse receipt.
So does it have to have the same moisture content as is set out in the grain card?
Well, if it's got a different moisture content, unless there's an explanation for the change, then. But I think that's delving too deeply into the evidence, because I'm not sure we've got evidence to say that any goods existed with that or a different moisture content. What we're relying on.
All the points you've been making about the ability of the inspectors to judge the quality would equally apply to the moisture content, the purity level.
Absolutely right.
And you say that it has to be, in order for it to be sufficiently identified goods to move on to insurable interest, it has to be of the exact quality described in the grain card?
It has to be the same description, which would include it has to be the same description, and if the quality in the warehouse receipt cross-refers to the card, the analysis card or the grain card, that's the description it has to meet.
So that if
I don't know how else
I
to.
insure a cargo in a warehouse and it happens not to be of the contractual quality in relation to moisture content, let's say, I'm not insured. Is that
Well,
an answer?
you've got to. Let's just assume. Let's put it another way. Just assume Quadra was delivered. Say if the grain card, which was referred to in the warehouse receipt, recorded a moisture content of 12%. Just assume that. And in fact, what was delivered was a moisture content of 13%, and other specifications which were at odds. Quadra will say, that's not our cargo, and they could refuse it. It's not our cargo. Now, if that's the loss that
Why
they're...
would they say that's not our cargo?
I'm beg pardon, my lord?
Why would they say that's not our cargo? There may just be an error in the sampling.
Well,
Maybe, but if that's the only problem with it, let's isolate it. If that's the only problem with it, then are you saying they wouldn't be insured because it had a moisture content of 13% rather than 12%?
Well, that's a very, I mean, there could be any number of explanations why the moisture content would change from the date of the card to subsequently. And of course, it could be the self-same cargo, and that I accept that. But if the warehouse receipts refers to grade 3 corn, and in fact it's grade 6 corn.
But I understand that, and you say that's part of the description.
Correct.
And you have to have goods that are identified of the same description. I was just trying to press you on how far that
Well,
went.
if the element of the quality relates to description, so that let's just for the sake of argument, there's no obvious reason why that quality specification would change from the date of the card to a later date, then that may reflect that it's a different description. It's not the same goods. If, however, the goods, there is an explanation for the change in this quality specification, for example, the moisture content, then they may well be the same goods, and you've got an explanation for the change. But when it comes to something as substantial as the crop year or the grade, then that does go to the description.
That's where you put the dividing line. Is it description rather than quality, is it? Or are you
Well,
saying
I think
it's not sufficiently identifiable if it happens to be of a different quality in terms of anything in the
what I'm saying is
contractual
if the
description?
quality goes to description, then of course it can't be the same goods if the quality or the grade or whatever it might be is different. If there's an explanation for the change in the quality specification,
Forget change.
okay,
Just suppose that it is not of the contractual
just say it's
quality.
graded at 6
The moisture
rather than-
content is, or the impurity content is different, not something that's going to change.
What if what the claimant has purchased is in a particular silo, and it's an identified silo, but it turns out there's a fraud because what they've been sold is 2017 crop and not 2018 crop, and 2017 crop is worth a lot less. But they paid for it taking delivery of it, and they don't find that out until after they've hauled it off somewhere. You're saying they wouldn't be insured because
no,
it's
because
different.
if they take delivery, they've got title unless they reject it.
Right.
So the title will give them insurable interest.
So the title will give them insurable interest in goods which, on your case, are not the same goods as they originally had an insurable interest.
Well, it depends when the loss occurred, I suppose. I mean, but the difference in this case, of course, they're not taking delivery. The loss here is
No.
so that's a material difference.
I suppose they're stolen before they take it.
Yeah, exactly.
Not insured, you say.
Yes.
If it's a 2017 crop, and the fraud is,
Well,
they've been treating it as theirs.
so why is it different, my lord, if I may say? If you say, well, we thought we had a cargo of barley, but it's actually a cargo of corn, and you take the barley anyway. It's not the subject matter insured. So why would it be different if it's a different grade? It shouldn't. It's like saying, I mean, if I put it back into specific goods, if I say I'll buy a car of a particular type, a brand, or a manufacturer, and actually something altogether, how can that be insured? It's not the right subject matter.
But it may depend on how it's been declared. If you've purported to insure what is there, even if title hasn't passed, then I do find it difficult for insurers to say, well, it's not insured just because you thought it was 2018 and it turns out to be 2017.
As a
Is that a
consequence
fair
of
way of
something
looking
which
at it?
you're not to blame.
Well, I think
It takes me back really to my question. Are we really looking at what the description is in the warehouse certificate, or are we looking at what's insured by reference to the declaration?
well, the claim is presented on the basis that the goods which have been lost are those in the warehouse receipt, referred to in the warehouse receipt. So if some other goods, then there's no claim being made for that loss under this policy.
Well, the claim was also put on the basis that these were cargoes that were declared to the open cover. I mean, that was the starting point for the insurance claim.
Yes, but no claim is made for any other type of cargo. Let's assume it just said declare corn without any other description whatsoever. And the claim is made for loss of grade 3 corn. But in fact, what's proved is a loss of grade 6 corn. That's not the claim being presented. My lord, I'm going to move on if I may, but I just want to make, my learned friend has got some response notice points on this issue, which it concerns the burden of proof. The only point I wanted to address is there's a suggestion, I think as I understand it, that the burden of proof somehow switched by the terms of the contract and the misappropriation clause, which you can see in the policy at the core bundle, tab 19.
Yeah.
Page 316. And you can see that basically the clause covers physical damage or loss caused by misappropriation. And then you can see it says risk covered under this clause. So, sorry, I beg your pardon. Towards the bottom of the page in bold, it says the above clause is subject to SMA and or CMA and or monthly external audit to be performed by a reputable surveyor. And I think it's suggested that those words somehow alter the burden of proof when it comes to demonstrating there's a loss. And we say that's, if that's the submission, that's not enough because you need express words to achieve that end, such as was the case in Levi, which is referred to in our skeleton. You can see at tab 7, where there are express words saying the burden of proof is, on that case, was on the insurer rather than the assured. Sorry, the insured rather than insurer. So I want to leave now this first ground and go to the second ground. And that's not to say I'm not prepared to take questions on the first ground if any further occur to you, but I'm going to move on. So as far as the second ground is concerned, so even if goods existed, it does not mean that Quadra had an insurable interest in those goods because the goods were not sufficiently identified. As I mentioned, Quadra has asserted an insurable interest based on title, right to possession, and having made an advance payment. And the judge rejected the first of those, but allowed the second and third. But we say in order to enable an insurable interest to be claimed in respect of each of these matters, there must be identifiable and identified goods to which each of these interests relate. And that means either the goods are ascertained, having been unascertained, or if they form part of a larger bulk, the bulk has to be identified. And we say that's for obvious reasons, my lord, because, as I've said, the very notion of insurable interest is between, on the one hand, is the relationship between, on the one hand, the assured, Quadra, and the other hand, the subject matter of the insurance. And until you know what the subject matter of the insurance is, it's not possible for an insurable interest to attach to that subject matter. Now, in this case, it was common ground that the goods were not ascertained. Now, when considering questions of title, so property, in this particular case, the judge held that there was no identified bulk. And that's why he held that title couldn't have passed. And there was another reason which I'll come on to. But in circumstances where the judges acknowledged and held that there is no identified bulk and they're unascertained goods, it is not possible to identify the goods in which or to which an insurable interest can attach.
Well, there's a logical flaw in that. For the purposes of title, there are some quite narrowly defined rules about whether the bulk is sufficiently identified, as it were, as one that can, your share in which can confer title. But in terms of simply looking at whether there's an insurable interest, if you have ground one, assume you don't succeed on that, you have got identified goods at the elevator, which are of the contractual quantity and description. They are part of a larger quantity, which is at the elevator. Why is that not a sufficient identification for the purposes of insurable interest?
Well, just assume, my lord, that there is 5,000 tons of goods, no more, 5,000 tons of goods. And multiple warehouse receipts have been issued in relation to those 5,000 tonnes. So you've got 6 claimant traders, each of whom allege or say they've got a right to possession of those 5,000 tonnes. I mean, of course, it doesn't have to be that high or that low. Now, just assume one of them can say, well, these goods have been appropriated to my contract. Just assume that's the case. For the others, it hasn't. Now, if my lord is right, so my lord, Mr. Justice Butcher, is correct, then you could have 6 traders making a claim for the full 5,000, each of them for full 5,000 tonnes in relation to only 5,000 tonnes which would have been lost.
That's why they pay the premium on the insurance.
Yeah.
But that means you will have only 5,000
Your
tonnes.
clients had the misfortune to be the insurers on all of them, so what?
Well, because if there's only, this is a physical loss property. So if there's only 5,000 tonnes, that means that 6 insurers will pay out a full indemnity to 6 traders, which will add up to 30,000 tonnes of loss.
Because
they've
on
all
this
paid for them.
hypothesis,
They've all paid for them.
because 6 traders have suffered the loss because they paid for the goods.
They may not have property in them. I
But-
entirely understand your argument that they can't all have property in the same parcel, but we know that insurable interest isn't dependent on property rights.
It's not independent on property rights, but what we say is, as a matter of, the reason why the law is in relation, that there's an insurable interest in relation to an identified bulk, is because it doesn't make sense, I would submit, that that there could be a loss, a physical loss of cargo, in which anyone has an insurable interest, if the goods aren't identified.
Well, suppose you have 6 different contracts, all identical, and there's only one parcel which conforms to each of them, and that is stolen, and they've all paid for for what they thought were different cargoes, but turns out to be the one cargo that's there. Now, why can't they have an insurable interest?
Well,
Just because there happen to be 6 of them and only one parcel.
So if I take my lord's example, so 6,000 tonnes, so 5,000 tonnes is sold to Trader A.
Yep.
Trader A has title, but it's still held by the facility. So the goods,
Forget title.
No,
Assume none of them have title yet, but they have all paid for it, and this is the cargo they've paid for. What's the conceptual difficulty
when you
with
say-
them all having an insurable
because
interest?
the question is, what is the cargo? The cargo has to be identified. So if it was just as simple as, for example, let's say this organisation, Agroinvestgroup's got 10 facilities across Ukraine, and they say, we will sell you 5,000 tonnes of wheat, not saying wherever, we hold it somewhere in one of our facilities. But those 5,000 tonnes are never identified. They're never appropriated to a contract. They're never identified as part of a bulk. There is a promise, we'll provide you with 5,000 tonnes. And then suddenly, there's a massive conflagration and all those facilities are destroyed. And in those circumstances, it's very difficult to see why that will give an insurable interest in all of the property held by Agroinvestgroup. Doesn't make sense.
But if the
That's a
insurers-
financial
no,
loss as
because
far as the insured is concerned.
If the insurers pay for 5,000 tonnes,
Mm.
the insurers paid for 5,000 tonnes, then the insured has an insurable interest in that for which he's paid. It doesn't matter where it is in your example.
No, you're absolutely right, my lord. There has to be an insurable interest for that which he's paid, but you have to identify what is it he's paid for.
I mean, you've got an authority for the proposition that you can't have an insurable interest in an unascertained bulk.
No, the Inglis and Stock. So sorry, if you have an identified bulk,
No, in an unascertained...
there's no authority either way on this question, my lord.
Because the Law Commission certainly appear to have thought there was no problem with insurance in that case. And I mean, it may be of no relevance, but the fact is those commodity traders who were consulted by the Law Commission were insuring day in, day out on that basis. The problem was a problem of title, not a problem of insurance.
What I say is the logic which applies to title, and this is the logic which is applied by, for example, Lord Mustel and Goldcorp, applies equally to any form of insurable interest, because you cannot be said to own something unless you know what that thing is. In the same way, you cannot be said to have a right to possession to that thing unless you know what that thing is. And you cannot be said to have an insurable interest in something unless you know what that thing is. And it's not just a question of law, my lord, it's a question of what I would say commercial logic.
We've answered that at the stage of issue 1. You say, don't know what the thing is. We do know what the thing is. It's a quantity which is at the elevator of goods of contractual quantity and quality.
Well,
They're at the elevator. If you're right on ground 1, we don't get this far, so we don't get onto ground 2 at all.
no.
So we're only looking at this argument on
Well,
the hypothesis that we have identified at Zablaski, let's say, 5,000 tonnes, 2018 crop.
No, because in fact, just imagine, my lord, that the Bastico inspection, first it's a Plasky cargo, inspected in October, say. Then they inspected again in December. They may have actually been shown a very different 5,000 tonnes than the ones they were originally shown. So you can't say.
Well, that goes back to your ground 1 with respect.
No, with respect, my lord, what Mr. Justice Butcher was saying is there was a physical quantity of goods without actually identifying, without it being sort of hallmarks, that were, as being attaching to a particular contract.
But if there's a different quantity later, then you've lost the first quantity, haven't you?
So then you'd be saying it's an insurance claim.
Certainly, because there's been a physical loss of that?
No,
property.
my lord, that can't be right for this reason, because it may well be that the goods will be appropriated to a different 5,000 tonnes will be appropriated to the sales of Quadra. That can't be a loss. So if the first 5,000 tonnes which was inspected is different from the second 5,000 tonnes which was inspected, and just assume the first 5,000 tonnes was stolen, that's not a loss to Quadra. They never have title to it. They have no insurable interest in it as such, because their goods aren't. All that was shown was 5,000 tonnes. It could be any 5,000 tonnes. There may be a whole, unless you can identify bulk from which you know the goods will be drawn for the benefit of Quadra. You cannot say they've suffered a physical loss. Now, I'll come back to the authorities, my lords. But all the authorities really do make it clear that what you have to have an insurable interest in is a thing identified. That was the language used by Lord Justice Waller in the Feasy case. And the logic which was used by Lord Mustell in Goldcorp, and I'll come back to that, it applies equally to insurable interest. There is no authority either way on this question, except the authorities which do exist. And obviously, and I'll come back to it, Inglis and Stock, which my lords will be familiar with. But Inglis and Stock was where the House of Lords said that when there was an undivided bulk on board a ship, you could have an insurable interest in that undivided bulk if you've only got, say, half the cargo. You've been promised half the cargo. And of course, this predated the changes to the Sale of Goods Act when it came to the title by 100 years. But the court held that there was an insurable interest in the undivided bulk, but that bulk was identified because it was a bulk of 390 tonnes on a particular vessel, a named vessel. Now, if you can say that there are goods which have either been ascertained, which means appropriated to the contract, or they're unascertained, but they form part of a larger identified bulk, then and assuming the goods exist, then of course you can see that there may well be an insurable interest in those goods. But unless you can demonstrate that, you cannot demonstrate the relationship between the assured on the one hand and the subject matter which has to be clearly designated in the policy on the other.
What do you mean by bulk for these purposes? Not for Section 20A purposes, but what do you mean by a bulk?
Well, I think that the definition of a bulk must, following Inglis and Stock, for example, is very similar. I'm not saying the statutory test in the Sale of Goods Act applies as a matter of statute, but it provides an excellent analogy because the Law Commission made it clear that it had to be an identified bulk. And they did so, as say, out of commercial logic rather than a policy decision. And it's in exactly the same way. And it's for this reason, and it goes back to the problem which I addressed earlier. If you've got a constantly changing goods within a facility, such as one of the Agroinvestgroup facilities in the Ukraine, and the goods are going in and out constantly, and all that's been promised to you to date as a trader is 5,000 tons of a generic description of goods. Now, it cannot be said just because those 5,000 tons which you inspected first or was delivered to someone else that there has been a loss. That can't be right. Because the trader may find another 5,000 tons to honour the contract which they've entered into with the trader. So there has to be an identified bulk, something which you know as the purchaser. And I'm not saying it has to be I'm not saying that has to be a property interest, but you know as the purchaser, because only as the purchaser you've acquired a right to possession or made an advance payment. You know as the purchaser that they're the goods I'm going to acquire. You can either point to either ascertained goods or you can point to an identified bulk. But if you're just going to say it could be any part of the stock which the seller happens to have, or may in the future acquire to honour this contract, that's exceptionally broad.
What's the difference between it all being in the same elevator and it all being in the same bin, which is constantly being restocked? Suppose you have a bulk in a silo and you've been promised 5,000 out of that silo and it's constantly being replenished, and then when you come to ask for it, there's none left.
Because
is that sufficiently ascertained to have an
No.
insurable interest?
No, but and for the very reason I've given, my lord, because if the goods are constantly being drawn upon and replenished, just because the goods have been taken out, if my lord's, assuming my lord was putting forward the question why that can't be a loss to the insured, the reason is because every time 5,000 tons was removed, that would be a loss to the insured, and that doesn't make sense.
But if there's nothing left at the end, he hasn't got an insurable interest.
That's a different. Well, if there's nothing left at the end, unless there's that's right. It's a commercial loss, because until there is property in which it can be said he has an insurable interest, until there's that property, all that has happened, he's outlaid money in exchange for a personal promise.
So in my lord's example, the insured is blissfully unaware that there's a problem with the silo, but he goes along at the end of the day and asks for his 5,000 tons and is told there's nothing left. You say there was never an insurable interest in 5,000 tons.
That's true, unless the goods have been identified.
Yeah,
But yes, absolutely.
So,
But why is it?
Even though that would clearly satisfy the Section 20A test. I know we're not on property, so that. But if you're saying that you take that as the yardstick, as the kind of bulk which is permissibly identified, he's got an interest because he's paid for 5,000 tons worth in that larger bulk, in that silo, throughout the entire period, and he doesn't get it.
Well, can I put another?
Say he's got no insurable interest and therefore uninsured.
Yes, and can I give you an example, my lord, just to make just imagine I decide I want to buy I want to buy a particular motor vehicle, and I want whatever brand you like. I don't care. You just choose it, whatever you prefer, and I decide, I go to a particular car dealer and I say, I want to buy one of these. And the car dealer's promised to deliver one to me. And he's only got 3 cars in stock, but he's already sold these cars to someone else. Now, just by paying the money to the dealer, the purchaser doesn't suffer a physical loss of the vehicle, because there's never a vehicle which was his, or at least was even allocated to him for the purpose of honouring the sale contract, because it belonged to someone else. So it's no different if you're talking about, an unascertained silo full of cargo, where 500,000 tons is being removed and replenished, removed and replenished, removed and replenished. unless you can actually say it's been earmarked, whether it's by ascertainment or by bulk, to the particular trader, there can be no loss. It's a financial loss, I accept, but it can't be a physical loss of goods. So if I carry that example over to the grain silo, just imagine all the grain in the silo has been sold, let's say 20,000 tons has been sold to 4 different traders, not including the insured. And the insured sees it and says, "Oh, I'm gonna pay." Now, they don't belong to the trader, they don't belong to the silo, but I'm going to pay anyway. That can't be a physical loss of goods to the purchaser. He's just made a financial loss. It's an awful financial loss, and he's a victim of fraud. But it's not a property loss. You have to identify property. You have to identify it as something in which the insured has an insurable interest. And without that, as regrettable it may be as far as the insured is concerned, there is not a property loss as far as the policy, a cargo property policy is concerned. And if I may say so, and I mean, this may be tendentious, I think this point is unanswerable in that sense, because all my lords have indicated by their questions is that it's possible for this person to suffer a commercial loss, but that's not enough. And it may be that you identify...
Can I ask you this?
Of course.
Do you accept that you can suffer a property loss in the sense of a loss in which you have an insurable interest under a property insurance without having any interest in the property, proprietary interest?
Yeah, and I think I've said that already, and of course the answer is yes.
So why is the fact that this is a property policy?
Yeah.
No, property
as you say, the unanswerable answer.
No, because property policy doesn't mean you have to have title.
Quite.
What it means...
Therefore,
What it means... Sorry, am I right?
yeah, sorry, but so I don't quite understand why you say it's a complete answer to this point, that this is a property policy, and you've got to have a
Well,
loss
no, on the
property.
So because...
If paying for the goods
sorry.
gives you an insurable interest
Yes, my lord.
in the goods, then when you suffer a loss because the goods aren't there at the end of the day because somebody's stolen them or because they've been sold to somebody else or whatever it is, that is a loss. That is a physical loss for the purposes of the insurance. It's
Correct.
not simply a financial loss.
Correct.
You don't have to have identified the goods in the sense that they were your property.
I agree.
Or you had a possessory interest in them.
I agree.
The fact they've been sold to somebody else because you're being defrauded is neither here nor there.
No,
in that example.
I think that's where you've got to... Whatever... I mean,
In your BMW example, you wanted to say BMW,
I did-
you couldn't quite bring yourself to say
That's not entirely
BMW
fair, my
example.
lord. I was going to say Rolls-Royce, but...
Well, no. In your BMW example, why does it matter if you pay for the BMW? If the dealer says that the BMW, this 5 Series or whatever it is, and you pay for it, you pay the price for that car, does it matter that he sold it to somebody else because he's a villain?
Well,
If you've paid the money for it, you have an insurable interest in it,
no,
and the test in Lucina and Crawford is satisfied.
no. Well,
So
don't
you
forget...
say.
Well, my lord...
Is that a convenient moment to break?
Yes, can I just say, I just want to make this mark up. My lord, or just Popplewell and my lord, the Chancellor, have asked me 2 questions. I don't think I've answered either of them yet. So, and I do need
I'm
the
sorry,
opportunity.
Mr. McDonald,
No.
because we are pressing quite hard on this.
No, but I there's a lot I want to say about this, and I think it's a matter of logic. The point I'm making is a good one, and I need the
Well,
opportunity.
you may be right as a matter of logic, you may be wrong as a matter of law.
Well, the matter of law, my lord, I think is I think law follows the logic here because there's no authority either way. I mean, I like to think law follows logic, and I've never been disappointed
Sometimes
yet.
it does and sometimes it doesn't.
That's
But you say it should.
not before this court, though, man.
Okay, 2 o'clock then, please, thank you.
All right.
Second question.